City Clerk, please take the roll.
Authority Member Bradish.
Present.
Authority Member Cole.
Here.
Authority Member Odell.
Here.
Authority Member Mather. Authority Member Lavier.
Here.
Authority Member Peterson.
Here.
We do have a quorum. Next item of business is approval of the minutes from our previous meeting. I have reviewed the minutes and I don't find any errors or anything that I disagree with. How about everybody else?
I'll move that we approve the minutes.
I will second that.
All in favor? Aye.
Aye.
Next
Mr.
item
Chair,
of
do we need
business-
to approve the agenda?
Oh, we forgot to approve the agenda. My mistake, I apologize. I make a motion that we approve the agenda.
Second.
All in favor?
Aye.
The agenda is approved. The one remaining item of business tonight is item 9A, Walmart Stores Incorporated doing business as Walmart Market number 3125 at 3615 Bowles Avenue.
The issue before the authority is whether there is probable cause to believe that Walmart Stores, Inc., doing business as Walmart Market number 3125, violated the Colorado Liquor Code and Littleton City Code and should be scheduled for a public hearing to show cause, if any, why its license should not be suspended or revoked. This matter comes to the authority as a possible violation of the Colorado Liquor Code and Littleton City Code by the licensee following the citation involving an incident on June 25th at approximately 8:30 p.m. of the licensee's employee for violation of Littleton City Code 6-4-102. Possible violations of the Liquor Code and Littleton City Code include Littleton City Code 6-4-102A, sale or dispensing of alcoholic beverages to any person under 21, and Colorado Revised Statute 12-47-9011. Attached to the licensing authority communication is case report number 2013003205. I also have a representative from the police department if there's any questions about that incident or how it occurred. Staff recommends that the authority find that probable cause exists sufficient to set the matter for a show cause hearing. The show cause hearing should be set on October 9th to allow for a preliminary hearing to be held on September 11th, which I think is a different date than we normally would meet during the month. Is that correct? No, this is the different date.
This is the different date.
All right. And that's in accordance with the licensing authority guidelines.
It appears to me that it's clear cut that there is probable cause.
Can we get a motion to approve the exhibits?
Oh,
before
I'm
we
sorry.
Do we have any?
That's okay.
Is that how we normally do it? I'll move that we approve exhibits, what is the letter, exhibit A?
A through
A,
C.
B, and C.
A through C. I'll move that we enter exhibits A through C.
I'll second that.
All in favor?
Aye.
Aye.
Sorry, a little rusty
Opposed?
because we haven't had.
Take a month off and we forget what we're doing.
I would agree that it looks to me like there's probable cause here that we should move forward.
I have no objection myself to that.
I have a question of the police officer out of interest. In reading the police report, it's different than the reports that I've seen before the authority before. Excellent job by the police department, as always with Littleton. Very meticulous about sending someone in to observe. I was not aware that that was typically the case. Is that a new practice, I'm wondering, by the Littleton Police Department? I know there's an officer outside observing, but was not aware that officers went inside to observe.
That's just the way they set up that operation at that time.
It's not typical. That was a one-time.
I'm not sure if it's typical, if it's a one-time ordeal or not. I know Detective Mullins, who was the investigator in this case, he used to be with the impact team or our set team, and the set team in the past would set up these operations for the police department. So he set it up the way that he felt it would be safe for the volunteers and for the officers involved.
Seems like a really good practice. If they could do that every time, that would be an
Yes.
advantage. I'm sure they,
I agree with
time-wise,
you.
they're not able to, but I would love to see that every time.
Okay, I'll bring that back to Sergeant Ward, the sergeant that's oversees the detective division.
Any other comments?
I'm going to make a motion. I move to find that there is probable cause to believe that Walmart Stores, Inc., doing business as Walmart Market, number 3125, 3615 West Bulls Avenue, Littleton, Colorado, on June 25th, 2013, at approximately 8:30 p.m. did violate the Colorado Liquor Code and Littleton City Code, specifically Colorado Revised Statutes 1247-9011 and City Code 64102A. Based on these findings, I move that a public hearing be set for the 9th day of October, 2013, for the purpose of considering the status of the license, wherein the above-mentioned licensee may be present to show cause, if any, why its license should not be suspended or revoked, and further that notice of these findings in the hearing to show cause shall be forwarded and served to Walmart Stores, Inc., doing business as Walmart Market, number 3125, at 3615 West Bulls Avenue, Littleton, Colorado, in accordance with the provisions of state law. I move that a preliminary hearing, if necessary, be set for the 11th day of September 2013 for the purpose of considering a possible stipulation, if any, between the licensee and the city of Littleton.
I second the motion. City Clerk, will you poll the authority, please?
Authority Member Bradish.
Yes.
Authority Member Cole.
Yes.
Authority Member Odell.
Yes.
Authority Member Lavere.
Yes.
Authority Member Peterson.
Yes.
Motion is carried. Next item of business is item 17A, oaths for witnesses and show cause hearings. I appreciate it if the city clerk would give us a little background on this matter.
The question has come up before, both with some members of the authority and with witnesses appearing before us to make presentations. And so I did a little research with other jurisdictions within Colorado and found that the majority of them do administer an oath for show cause hearings. In conversation with the deputy city attorney, we felt that if we are going to do that for show cause, we should probably also do that for new applications, since we do have people coming in to testify that their applications are complete and true and that kind of thing. And so I just wanted to bring it before the authority to determine if this is something that we want to do. And if so, I've pulled together a few examples that are used in the other jurisdictions so that we might come up with something, or if you feel it's necessary at all.
Does the oath bind them in any way? They're not,
I'm sorry, could you repeat
does
it?
the oath bind them in any way? Would it be, it wouldn't be perjury, would it?
Well, I suppose it could be perjury. Tricia would appreciate it, I think, if we did have them administer the oath. We do have them, they do affirm, I think, actually under penalty of perjury, their applications, and they do have a duty to be truthful with you. So I think it adds a level of seriousness and formality to the proceedings. Is really the key benefit to it. It also helps if there's any sort of legal action afterwards, if anyone were to challenge you. The fact that we received the oath, or received the testimony under oath, I think the court gives that more weight. So I would recommend it.
Who would administer the oath?
in jurisdictions I've worked with and seen, it's the clerk that administers it, and there are two ways I've seen it done. One, she can administer it each time someone gets up to testify, or if there's a number of people testifying, you can do a group oath. And just do it at the beginning of the meeting. If you're going to testify, please stand up and we'll take the oath, and she gives it to the entire group to save time.
I think it's a good idea. The ones that I've seen, usually the chairman will issue, or chairperson will issue the oath to each individual one. That's what I've seen.
Or the chair could. Mhm.
That would work too. I think we should do it. I've been in a couple of conversations about this in the past, and it's been a feeling of mine that it just raises the level in a person's mind that they should tell the truth, since they just swore that it was the truth.
Is the idea that everyone who would testify in any way would take it? So, for example, an applicant, they have obviously a pretty significant stake in being truthful, but someone who just came and said, I guess my point is, would anyone who gets up in front of us be asked to take it?
Well, I think that's up to you. I would definitely recommend it for the applicant or the licensee. But I have certainly been in hearings where if you're going to be presenting evidence to the authority, we want you to affirm that the evidence you're presenting is truthful to the best of your knowledge.
And so that might carry over to if they hire someone to do their petitions or anything like that.
Right,
Members of the
yeah, and that
public.
makes sense. I just mean, for example, if you had, like when Walmart came in and they had a neighbor there in the strip mall and she, owned like a sandwich store and she just came in and said it would be nice if there were more people here to go to, would we have a person like that give?
I would think so.
I don't see any harm in doing it. But if you don't
Right.
want to, I don't see any harm in not doing
Right,
that
right.
either.
Sure,
But you are relying on her testimony
Right.
in that instance.
yeah.
There is a possibility that people might be a little more reluctant to appear as witnesses, knowing that they're going to be sworn, but
That's the only-
to me, that means maybe we shouldn't have them as witnesses in the first place.
Yeah, no, I agree. That's the only drawback that I was getting at, might just be that it could be a little more intimidating. But I mean, I would tend to agree. I'm not trying to be difficult. I think it's true that, if you're going to get up here in a public setting and testify, that I'm fine requiring it.
My best point of reference in my experience has been the Safeway hearing for their license, where there were so many people that wanted to speak, and it was a long meeting to begin with, but if we swore all of those people under oath, it would take a little more time. But in that case, there probably would be fewer people wanting to repeat themselves, which is always a problem. So I think we need to move forward from that. Do you want an opinion right now about which of these?
You don't have to make a decision right now about which one. I mean, you can take some time, mull it over.
I prefer one of the, either 3 or 4.
I really like one just because it's simpler. It seems less legalese, which I would prefer, but.
I tend towards 4. I agree about the simplicity. If a witness is that important for us to hear their testimony, they can always be subpoenaed if it really is that important by either of the party. If it's not that important and they're reluctant. But number 4 does accomplish what we're saying. If they're going to swear an oath, this is one that people are familiar with, and the last phrase now before the Littleton Licensing Authority adds specificity to it. It's very, very specific. I prefer 4.
I prefer 3 or 2, something more simple, and I think it says before this authority, it kind of, this is this authority, so putting Littleton in, there's much more specificity.
And then For me, number 2 has my vote, but I don't think it entirely matters which one we pick. But I do believe they are kind of graduated, so the further down the list you go, the more reluctant the person will probably be to come forward. So if you want to elevate people by requiring an oath to begin with, just by getting number 1, you've done that. And if you go all the way to number 4, you're really raising that bar, I think.
We're probably not going to vote on these, I assume.
Well, I would like there to be some sort of consensus, because I want there to be continuity. If we're going to do this, it needs to be the same each and every time, and it needs to be something that you as a collective are comfortable with. Wouldn't
Okay,
you agree?
let's see the status now. No one favors number 1.
I liked 1, but I could be persuaded to go with 2. I mean, if that's where we're going, then I'd rather have 2 than 3 or 4, so.
Okay, so is there anyone who prefers 1? So we have 1 who prefers 2. I assume that's 2.
I prefer to.
I'd like to as well.
That's 3. Donovan, you're probably going to go with 3 or 4 like I am?
Yes?
3 or 4?
I prefer 4, but 3 is completely acceptable.
Okay, I'll go with 3. So the majority, 3 to 2, favors option number 2. And I think we can proceed along the lines of that being the oath.
And are you going to give that, or do you want Colleen to do that?
To administer the oath? I can do that.
Okay.
Now I'm even more glad that it's one of the short ones.
I know Tricia will appreciate that, because I think her concern was being able to use this testimony in court proceedings, and the fact that it's sworn to.
Well, I think we've all watched so many movies and TV shows where the whole truth, nothing but the truth is said, that I kind of like that, but this gets the job done just as well.
I do have one other matter to inform the authority about. The council is looking at licensing for retail marijuana establishments. We did have a study session on July 9th, and they are interested in having me bring forward an ordinance to license retail marijuana establishments. We have a follow-up study session next Tuesday to talk about whether they want to only allow the retail marijuana stores, or if they want to consider allowing other types of establishments like the manufacturing facilities, the testing facilities, and the cultivation facilities. And I also will be giving them my draft ordinance at that time. It's set up very similar to the way the medical marijuana licensing is handled right now in the city, so those applications would come before you, as well as any probable cause, show cause hearings. If it's okay with you, I will send you a copy of that draft, and if you have comments, I'd appreciate if you send those to me, or anything you want relayed to the council at the study session. If you send that to me before Tuesday, I'm happy to pass that along. And then any comments on the ordinance, if you can send it to me before it goes to first reading. We are trying to put it in place before our October 1st deadline.
I only have one question at this point. It's pretty obvious to me that we're going to have the outlets, some number of the outlets. Is council's intention to limit the number as they did with the medical outlets?
It's unclear right now. We didn't get to that question because they wanted more information on each of the other types of establishments. Staff had kind of assumed that they would only do the stores if anything, and they might not do anything, and they were interested in the other type of establishments. So it's unclear right now whether it would just be limited to the 4 we have, allowing them to possibly convert or do dual license, or whether they would allow additional facilities, and then whether they would allow even additional licenses to be issued for testing facilities, cultivations, and manufacturers. So I don't know, but if you watch on July 9th, I think you'll get a good sense. Not July 9th, on Tuesday.
My concern was remembering the medical outlets, and the situation we were in where there were only going to be 4 allowed and there were already 6 in existence. It was a difficult situation, and I hope that we wouldn't get in that situation again.
I don't think we would get in that situation. We have a moratorium in place, and they're not going to touch the medical marijuana regime. So certainly, at a minimum, those 4 would be allowed to continue doing what they're doing. It's just whether or not we're going to allow them to convert to retail or operate both. And then perhaps even whether new licensees could come in if they open up the number.
You said that you have a moratorium on right now. When is it the first date that you will accept applications then?
Well, so the state has set up a procedure where people who are currently licensees or applicants have a head start on everyone else, and we will be following the state
okay.
phase-in
Okay.
guidelines. The council was clear that they didn't want to vary from that.
Okay.
So that's the way it's
Thank you.
been drafted.
Mean people who currently have medical marijuana dispensaries?
They get first shot at the retail, and then anyone who's an applicant in the process. So, and we obviously don't have any of those either, so. Any other questions? Otherwise, feel free to email me or call, and I'll be happy to pass those comments along. And then otherwise, I just would appreciate your review of the ordinance and any thoughts you have.
Can you send them to us as soon as possible? Because you said Tuesday, right, is the study session?
Yes,
Okay.
so I haven't even actually, it's going in packets tomorrow for council, so when it goes in packets, I'll send it to you as well.
Great,
So you'll have the weekend.
okay.
But feel free to, it won't be going to first reading
Right,
until,
right.
so we have some time,
Okay.
but.
And then I just have one question. Now, anyone who knows the answer might answer, but did the state set up more restrictive zoning requirements in terms of the distance requirements? Or is it still the same?
That's a local
That's a- yeah.
issue,
But
yes.
that's
And
right, yeah.
the way it's drafted, the way I drafted it, which could change, is that it's the same restrictions that we have on the medical marijuana. I think it's 1,000 feet from schools and parks, and I can't remember exactly. None can be located in a residential unit, building with a residential unit, things like that.
Okay.
So then we'll be regulating not only the outlets, but the production, the growers.
I don't know. We're bringing back more information on what those are, and council will
But-
decide.
But the city would have to affirmatively
Yeah,
allow the
allow
other,
them,
right? Okay.
And they can pick and choose which ones they want, right? They can deny
Yes,
the
they could say-
testing and the grows.
They could say none, we don't want any retail. They could say we just want stores. They could say we just want testing facilities. So, yes.
Okay, so we're a long ways away from answering that question.
Well, next week, I think we'll have a better idea.
Are we finished with that
Yes,
item?
thank you for your time.
Anyone else have any items you'd like to cover at this time? There being none, I would entertain a motion to adjourn.
I'll move that we adjourn.
I will second that.
All in favor?
Aye.
Aye.
Meeting is adjourned.